Mr. Globus, I have to do the Riverview in custody first because it's in custody. I know I said I was gonna do that one next, but I have to do this one. Let's go on the, oh, Mr. Solers is back in custody. Okay, let's go on the record in the matter of the state of Michigan versus Brandon Solers, 26556.
Yeah, Your Honor, John Goldclaw, P 30758, on behalf of Mr. Solers. Solers, please put your name on the record.
Good afternoon. My name is Brandon Solers.
Okay, good afternoon. And so counsel, as to arraignment for your client.
Solers is charged with 1 count of domestic violence. I have discussed this matter with him. Mr. Solers would plead, I'm sorry, he would stand mute to the charges, waive a form reading of that charge, ask the plea of not guilty be entered.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And the court will schedule this matter for pretrial.
Welcome to Court Tracker, where real courtroom moments unfold in the most intense way. Today, we jump straight into a fast-moving arraignment involving Mr. Solers, where the court immediately enters a not guilty plea on a domestic violence charge and moves forward with scheduling the next hearing. From the very beginning, the judge keeps the process moving quickly, waiving formal readings and addressing timing issues for the pretrial date. Even though there's a slight delay beyond the standard window, the defendant agrees to waive the time so the case can proceed. What starts as a routine hearing is already setting the tone for a much deeper review as the court prepares to discuss bond, probation history, and the defendant's current situation.
Counsel, the next date, well, the 14 days would be, would be 1 day outside the 14 days for May 14th. Do you want to go over time with your client?
I have no objections to that, Your Honor.
Okay. Can you just go over that with your client on the record though, please?
Mr. Towers, you have an absolute right to have your pretrial scheduled within 14 days of the arraignment. The next state date, which this is a state case, is not available until 15 days from today's date. Are you willing to waive that 1 day with respect to that?
I am, and I'm also asking for a personal
We're going to get to
bond.
that. I understand what you're asking for, sir.
Okay. So the court then will waive the time. The court will also schedule this matter for pretrial on May 14th.
10:15.
I'm sorry?
10:15.
Okay. All right, counsel, as to bond.
As the bond, Your Honor, Mr. Solers is 35 years old. He is on probation to this court. He's not on parole. He is on probation to this court. And I believe that's for a person or.
Right, it was a restricting and it was an R&O. That was amended, let me see here.
According
There
to,
was an R&O that was amended, a felony obstructing police that was amended to disorderly conduct.
I
He
just,
was just sentenced December of 25.
that is correct, Your Honor. It's also my understanding that he did have a no ops conviction in this particular court. He did 10 days on that as well. He is not employed at this point in time. He's informed me that he is looking into becoming for disability because he has epilepsy. We're asking for a bond. He's asking for a personal bond. I indicated that based on his probation status, etc., that I did not think that was likely, Your Honor, and we now have a court date so we can address these issues.
Well, sir, who's your probation officer?
Miss Miss Shaw.
Miss Shaw or Miss Shine?
Mrs. Shaw. Mrs. Shaw.
Okay, all right.
And I did indicate, Your Honor, that I anticipated that a probation violation.
Hey, can I
Would be-
say something, Your Honor?
I would suggest you don't at this point in time, but that's up to you.
If you want to speak, sir, oh, you sure can.
Well, I just wanted to say that I have appreciated what the court has done for me so far. Mrs. Shaw has been a very respectable probation officer, and the argument that I had got into with my mom last night.
Sir, you may not, sir, I don't want you speaking about the case.
All right.
Not talk about the case.
All right, and so, sir, where do you live?
I live in Riverview Towers with my mother.
Really? She claims that you're not supposed to even be there.
She has let me stay there against the manager's word. She has went against the manager's word to let me stay there until I had got some money together just so I could have enough money to get a car.
Well, sir, where do you work?
I don't have
this time.
I don't have a job at this moment.
Why not?
It's been hard for me to leave out of that building without being seen by the management. And my mom has asked me not to do that. So I have not been in a position to be able to leave out, with my mom asking me not to leave out of her building because this lady that she lives with, Mary, is trying to give her all these problems. And
Sir.
Okay.
Sir, let me just say this. First of all, by staying with your mom at the Riverview Towers, you're putting her residence in jeopardy because you're not over 55 or whatever the age limit is, the minimum age that you have to be to live there. Second, you're telling this court, I'm not sure if you've heard what you're saying, but you're telling this court that you've chosen not to work so that you could stay with your mom improperly.
that's not
Thereby
exactly
not-
what
there-
I'm
there-
saying.
Please hold on. Thereby not being able to work, now you can't get a car, so you can move out.
That's
That
not
doesn't even make.
exactly what I'm saying. It might be what you have heard, but the jobs that I have access to are, for one, because I have epilepsy, the ones that I have access to. I have epilepsy and I'm just now starting to feel like I need to go to Social Security office and claim for disability.
Okay, well, that is something different than what you said the first time. But in any event, I'm going to help you with all that because you're not allowed to return to the one address. You're not to have any contact with your mom. That's phone contact, text message, email, social media, third party, anything of the like. You are also, sir, not allowed to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to firearms or weapons, and you're not to be released without a GPS tether through the Wayne County Jail. And the court's going to also indicate a $10,000 10% bond.
Holy shit.
I'm sorry, sir. You're on the record. That's not appropriate. The court wants to ensure the safety of the public as well as the safety of Miss Moore.
Thank you very much, Your Honor.
Thank you. Have a good day.
Thank you, Your Honor.
Thank you. We are on the record in the.
And now the hearing takes a serious turn. As the judge reviews the defendant's background, Things begin to shift toward his living situation, employment status, and medical condition. Mr. Solers mentions epilepsy and difficulty finding work, but the judge carefully examines inconsistencies in his statements and raises concerns about responsibility and compliance. What follows is a strict set of court orders: no contact with his mother, GPS monitoring, and restrictions on substances and weapons. The judge makes it clear that public safety and court compliance are the priority. Finally, a $10,000 bond is set, and the courtroom tone becomes firm and final. The case moves forward under strict conditions as the hearing concludes on record.